Welcome, welcome. So glad that y'all are able to join. We're excited for today's conversation. Just gonna give a couple more minutes for people to join and then we'll get started.
Is that your cat?
That is my cat. Goose might be making an appearance. He's very vocal this morning.
Amazing. All right, well, I'm going to go ahead and get started. I know that we'll have more people join in a minute, and we'll have people on Facebook Live also joining in as well. But welcome so much to this rainy Wednesday's Ask an Attorney session with the Legal Rights Center. We're excited to talk about the first couple of days of the Chauvin trial and answer questions that you all might have. I'm just going to give a little bit of intro to the Legal Rights Center and the way that today's session will be structured, and then we'll go ahead and dive right in. So thanks for being here. The Legal Rights Center is a nonprofit community defense law firm. Our mission is to work with our communities to seek justice and promote racial equity for those to whom it has been historically denied. We do this through criminal defense, restorative justice, advocacy, and community education. Our offices are located in downtown Minneapolis, and we serve young people and adults in Hennepin County Criminal Court. And as a means of supporting our community through the Chauvin trial and the upcoming trials for the other 3 officers involved in George Floyd's murder, we've been actualizing a community support plan focused on 3 prongs. First, community education, so sessions like this where we're helping our community understand the different aspects of a criminal trial and the specifics of the Chauvin trial. We also have resources on our website related to restorative processing, because we know that these trials bring up the trauma and can trigger significant emotional reactions as our community all experienced George Floyd's murder in different ways. So we have tools on our website if you're seeking to process the trials with people in your community. And we're also offering legal support in partnership with other community partners to make sure that folks who are out there demonstrating and expressing their First Amendment rights have access to legal counsel if they need it. So we'll share our website at the end of today's session where you can find all of these different resources, but we just want to dive in because we know that y'all came here to hear from our great attorneys, Nick and Josh, in just a second. So the structure for today's Ask an Attorney session, we're really going to focus on the 2 major issues that have come up in the first 3 days of this trial, specifically the charges in the Chauvin trial, and we'll have a deep conversation about this Court of Appeals, this deliberation on 3rd-degree murder. We'll also talk about jury selection. We had a full day of it yesterday, and we'll talk a little bit about how jury selection typically happens and how it's going in this trial. And then we'll save time at the end for any other questions that haven't been answered. In this Zoom function, you have the ability to chat into the panelists any particular questions that you have, or use the question and answer function. So feel free to send your questions in either now if you have them already, or as we're going. For each of these topics, both Josh and Nick will spend a little bit of time just giving some context and like, whoa, how did we get there? And then we'll open it up to questions from the entire group. So with that, I will stop talking and I'm going to turn it over to our team to introduce themselves. I'll just share that my name is Malaika. I'm the Community Strategy Lead at the Legal Rights Center, and my job today will be to help make sure that your questions get answered. So I'll pass it over to you, Josh, to introduce yourself, then Nick, and then let's get started on the charges in the Chauvin trial.
All right. Hi, everyone. I'm Josh Esmay. I'm one of the attorneys at the Legal Rights Center. My work focuses mostly on defending adults in criminal court and helping people address what we call the collateral consequences. So the impact of having a record and how that affects lots of other areas of life, like employment and housing and that type of thing. I just want to add one quick thing to Malika's excellent introduction of kind of the structure for today, which is we are almost certainly not going to be able to talk about everything in the hour that we have today, and we are planning more of these as the trial goes on. And so, ask your question. If we don't get it to it today, we're going to be putting it in the can, and it'll be something that we address as we move forward through the trial process. We kind of picked the topics to today to really sort of focus on kind of what has happened so far this week. Nick, you want to introduce yourself?
Thanks, Josh. Hi, everybody. Welcome. My name is Nick Pouladian. I'm an attorney at the Legal Rights Center, focusing on adult representation in criminal court. Really happy to be here and really happy that folks are tuning in. Obviously, there's a lot going on, and we're happy to help address and discuss and answer questions and really engage the community with this. So thank you for being here. Like Josh said, we won't be able to get to everything, but please feel free to ask away. And maybe at a later session, we'll be able to. Back to you, Malika.
I'm actually going to go to Josh here. Josh, you want to get us started on the charges in the trial?
Yeah. So am I going to get to share screen?
You should be able to, but let me know if you can't.
Let's see. Share screen. All right. Okay, so we had a lot going on late last week and then over into Monday with the status of one of the charges that the state is trying to bring against Derek Chauvin, which is the third-degree unintentional murder charge. And so I want to have a conversation about that and kind of run through sort of how we got to where we are and what the issue is and how it might affect things going forward. But I kind of thought that the best place to even start before we got to that is to actually just sort of go through and outline what the charges in the case are. So right now there are two charges that are a part of the case. Those are the second-degree unintentional murder charge and the second-degree manslaughter charge. And then we're basically waiting to see if the state is going to be allowed to also bring a third charge, that being the third-degree unintentional murder charge. So what are those? So I kind of just want to run through kind of the definitions, or what the lawyers will call the elements of these charges. And so what a criminal charge basically is a set of criteria that the state needs to prove beyond a reasonable doubt in order to obtain a conviction against the defendant. And so ultimately what happens is at the end of all of the evidence, the jury will get a set of instructions that will basically include these elements laid out with sort of a yes or no. Do you find that this fact has been proven by the state beyond a reasonable doubt? And so you can kind of, each of the bullet points here is going to sort of roughly correspond to one of those elements that will be in the jury instructions at the end of the trial. So second-degree unintentional murder, this is sort of the top count. What it requires the state to prove is, first of all, that whatever Derek Chauvin did was the cause of George Floyd's death. That's going to be a running theme through all three of them. And then second degree basically works like this. It's sometimes called a felony murder charge or felony murder doctrine. And basically what it says is that if somebody causes the death of another person while committing or attempting to commit another felony, then that's how we get to second degree unintentional murder. It doesn't require the state to prove that Chauvin intended to cause the death. It does require the state to prove that Chauvin was committing or attempting another felony, and then as a result of that felony, that it caused George Floyd's death. And so we call that the predicate felony, sort of the underlying felony, and that basically becomes wrapped into the charge. The elements of that predicate felony become elements that the state needs to prove in order to establish the second degree unintentional murder. And so here the predicate felony is assault in the third degree. That basically requires the state to prove that Chauvin committed some intentional act. He intended to do what he did. It wasn't like a mistake or an unintended thing that he did. And then that that intentional act then caused significant bodily harm to Floyd. I don't think the significant bodily harm is going to be a pretty big issue here. Significant bodily harm just means temporary but substantial impairment of a bodily function or substantial disfigurement. But the case law is pretty clear on that, like, getting knocked unconscious and certainly death would fit that standard. So that's sort of, in a nutshell, second degree unintentional murder. The big concepts here are the predicate felony and what the state needs to prove for that predicate felony. It's a lot different, actually, than third degree unintentional murder. So third degree unintentional murder, this is the one that we're waiting to see if the state is going to be allowed to add to the menu here. Is going to be, sort of a cause of death again. Chauvin's actions had to cause Floyd's death. And then the action is different. We're not talking about like a predicate felony now. It's got to be an intentional act that was imminently dangerous to others. And I've underlined others. Stick that, put a pin in that for now. That's going to become a big issue here in a second. So intentional act that's imminently dangerous to others. And then it has a different intent element than we saw in the second degree. The intent element here is that it's got to be done with a depraved mind and without regard for human life, which basically means that Chauvin sort of knew that what he was doing was imminently dangerous to other people, and he did it without regard for that danger. And then the third charge here is the manslaughter. Manslaughter works a little bit differently. It is organized around the idea of negligence. So an action that causes death, that action is gross negligence. So that means it is a gross deviation from the standard of care that we would expect a reasonable person to adhere to in the same situation. It's a sort of an objective standard where we're looking at what the person did. How different is that from what we'd expect a reasonable person to do in the same scenario? And if it is, grossly different from that, significantly different from that, that's the element the state would have to prove. And then in addition to that, they need to prove the mens rea element of recklessness, which means, again, the state would have to prove that Chauvin was aware that this was risky and consciously disregarded the risk. And that's different from the previous element because it's subjective. So the state has to prove sort of objectively from the perspective of a reasonable person, how do we want them to act in this situation? And then if that is a significant deviation from what we'd expect them to do, they also have to prove that Chauvin subjectively in his mind consciously disregarded the risk that his conduct created. So those are the three charges in a nutshell. Let's talk about what the heck is going on with this third degree murder charge. And I've kind of put together sort of a rough, kind of timeline of how we got to where we were. So back during the summer, the initial charge that came down amidst a lot of sort of public outcry about the initial charge for a few reasons, including a bunch of language about sort of George Floyd's medical situation that was in the complaint that seemed to be sort of setting up the defense already, which is pretty different than what you usually see a county attorney include in a complaint. But the other sort of part about the public outcry was what they decided to charge. They initially came with just the third degree murder charge. Well, the third degree murder charge and the manslaughter charge. They didn't initially charge second degree. And that caused a lot of concern, including at Legal Rights Center, because a lot of us sort of looked at that third degree charge and sort of looked at the elements of it and the history of it and thought, well, heck, this does not fit the facts here. And the issue that we were concerned about even back last summer goes to what I underlined here, others. There was a lot of case law going back like almost 100 years that basically said that this third degree unintentional murder, the depraved mind murder charge, is supposed to fit a situation where someone's action is dangerous to others with an emphasis on the plural there, like a group of people. And there are some cases that have specifically said that we don't apply this when someone's action is intentionally dangerous but directed at a single person. And so with the, with the facts that everyone was aware of just from watching the video over and over again, it's pretty clear that the Chauvin's actions are directed, only at Floyd. And so that seemed to be a pretty big concern, that this, not that there was no crime committed, but that this third degree charge was the wrong charge to fit the crime.
Josh, I'm gonna just interrupt real quick. So
please.
you mentioned case law and you've mentioned precedent. Can you talk about what does that mean? What is case law? What is precedent, and why does it matter?
Good question. Thank you for giving me the opportunity to clarify that. So what happens with case law and precedent is you've got the court system set up in Minnesota in basically 3 tiers. You've got the trial court. That's where the day in and day out action happens. That's where the trials happen, the guilty pleas happen. That's where the cases start. And then you've got 2 levels of courts above that we call the appellate level, so the Court of Appeals and the Supreme Court. And those courts' function is basically to correct mistakes that are made by the lower courts. And that process then is, if you're, something happens in the trial court that either party thinks was wrong, and then they file an appeal, and the Court of Appeal looks at it and hears arguments about why it was or wasn't wrong, and then makes a decision. And those decisions that they make, especially in situations where, really what they're doing is clarifying something that isn't clear, like if there's a question about the law, their decision then becomes precedent. And from here on out, the lower courts have to follow that rule that the higher level court decides. And so a Court of Appeals decision becomes precedential to the district court, to the trial court, and then a Supreme Court decision, if it goes up that other level, becomes precedent both to the Court of Appeals and to the trial court going forward. So yeah, that's kind of what we're talking about with precedent. So kind of coming back to our timeline here. So we got the initial charge. We got the legal community looking at it and saying, hey, based on precedent, this doesn't seem to fit. And then ultimately, once the case got, once the Attorney General's office got brought in, they looked at that and obviously agreed. And so they added that second degree murder charge, which, just setting aside whether or not any of the allegations are true or what defenses might be applicable, the second degree murder charge, at least at the time, definitely seemed like a much better fit. You could clearly see how the state could be arguing that what Chauvin did was a third degree assault and that it caused Floyd's death. So then we start to get into the case a little bit, and we move into the fall, and Chauvin, at this time the trial was still joined, so both Chauvin and all the other co-defendants filed motions to dismiss for lack of probable cause. So what happens with this is sort of a pretrial motion where a defendant can ask the judge to take a look at the case and say, look, even if we assume everything the state is saying is true, and even if we draw all the inferences that we can in favor of the state based on that information, there's not enough evidence here to even let the case go to trial, because what happened just does not amount to a crime. The defense made that argument with respect to all of the charges, although, I think those of us looking at it thought, there's pretty obviously probable cause for the second degree and for the manslaughter charge. But it didn't really surprise me. My guess is it didn't surprise Nick that Judge Cahill granted the defense's motion to dismiss that third degree murder charge for lack of probable cause, because Judge Cahill looked at all that precedent that all of us were looking at and said, look, there's a clear rule here. This is others here means that it may not, the action here may not be specifically directed at a person whose death occurred. I put those in quotes because I actually just took that straight from Judge Cahill's order, and he was citing to appellate court case law there. So he basically said, yeah, it's directed at one person. The rule says this charge doesn't apply in that situation. So he granted Chauvin's motion to dismiss for lack of probable cause. that set up the fireworks, basically. So about a month ago, early in February, the Court of Appeals issued a decision on the conviction and the appeal by former Minneapolis police officer Muhammad Noor. So you guys may remember that Muhammad Noor was the police officer who was convicted of third-degree murder when he shot out of his squad car and hit a pedestrian, killing her. And so he was convicted after a jury trial. His case had been kicking around the Court of Appeals, and just sort of coincidentally, I think we get a decision just kind of on the eve of Chauvin's trial. And the Court of Appeals did something a little bit surprising here. They upheld Noor's conviction, and that part's not surprising. But the way they went about doing it is Noor was arguing that his case should be dismissed because his actions were directed only at one person, the victim, the pedestrian that he shot and killed. And the Court of Appeals, I think, could have said, no, your action was reckless and could have hurt multiple people because he was in a squad car in a residential alleyway. His partner was right there. All about that could have said, look, your actions were directed in a way that was dangerous to multiple people. But instead, the court didn't do that. Instead, the Court of Appeals broke from that historic precedent that Judge Cahill had relied upon and said, no, this third-degree murder charge, this works even if it's directed only at a single person. Yeah, the word here is others, it's plural, but plural includes the singular. And so we're gonna say that even if Noor is correct that his action was only directed at one person, that's okay. Third-degree murder now applies in that situation. So this is where it gets tricky, because now that is at least arguably precedent. That's a Court of Appeals decision. It was a published decision, but it breaks from previous Supreme Court precedents. And everybody knows that Noor has petitioned the Supreme Court for further review of it. So they're going to have the ultimate say on this question of whether third degree applies to a singular person or not. And so that's the situation we're in just a month before Chauvin's trial is set to start this week. So then based on that, the state brings a motion to reinstate the third degree charge. That motion was denied by Judge Cahill. It's unclear. I think it's, maybe fair to speculate that Cahill kind of thinks that the Court of Appeals, well, let's just say he certainly recognizes that the Court of Appeals decision was a pretty big change in the law, and that's something that the Supreme Court is going to have to look at. But he denies it mostly on kind of technical or procedural grounds, saying it's not yet precedential because it's still working its way through the Supreme Court and the appellate process. So then Friday, just before noon, so, just hours, in terms of work hours, half a business day before the trial is supposed to start, the Court of Appeals reversed Cahill's decision and remanded it back to him and saying, no, our Noor decision is precedential to you, Judge Cahill. So that's not a good reason to deny the state's motion to reinstate. And so that's sort of where we're at first thing on Monday morning. Is the Court of Appeals has told Cahill that he was wrong to deny the state's motion to reinstate. And so we're figuring out where to go from there. Chauvin's attorney on Monday morning basically says, look, we're going to ask the Supreme Court for further review of this. And so basically, judge, because this issue is still pending with the Supreme Court, you can't actually make a decision about whether or not the third degree should be reinstated. So then there's this question of, okay, well, what do we do in the meantime while we wait for the Supreme Court to issue a decision on Chauvin? The court very clearly just wanted to move forward with things. The state was seeking to basically have things put on hold have voir dire put on hold while we wait for the Supreme Court to decide that issue. So they asked Judge Cahill to do that. Judge Cahill declined, said, no, we're moving forward, but recognized that the state had one more tool in their toolbox, which was to seek an emergency writ of prohibition. So basically, this is the state going back to the Court of Appeals now to argue that it's wrong to let the trial go forward while we wait for the Supreme Court to decide the issue, and asking the Court of Appeals to order the trial court to stop the proceedings. And that's basically where we're at today, with sort of two separate issues, separate but related issues kicking around the Court of Appeals. We're waiting for the Supreme Court to decide to decide on Chauvin's appeal of the Court of Appeals order reversing Judge Cahill's order not allowing the third degree to be reinstated. And then we're also waiting to see if the Court of Appeals stops things.
So Josh, it's sort of like like Inception, the movie Inception, a dream within a dream within a dream, or a Russian nesting doll. So are these processes, are these appeals quick? Why can't the Supreme Court or the Court of Appeals, why can't we just push pause for today and tell the court, hey, figure this out and then we can start tomorrow? Is that something they can do on that timeline, or is this a lengthy process?
Especially the emergency writ of prohibition would be something I'd expect to happen quickly. I think the Supreme Court could probably move quickly too, but quickly isn't necessarily a matter of days. It doesn't surprise me that we don't have an answer yet today for things that were filed on Monday. I don't, in terms of the timeline for the Supreme Court, I'm not exactly sure how long that would take, but I would think that we would have a decision from the Court of Appeals before that, and that could be, I would think that could be any day. Do you have a different sense of that?
No, I agree with you completely. I think the Court of Appeals, at least for that emergency writ, is going to be, faster. Honestly, I was expecting it, sooner than even now. But in terms of the other things, I agree with you completely. Yeah.
Josh, I know one of the things that you wanted to get to is coming in. It came in a question from an audience member, so I wonder if you could answer it now. I mean, why is the state moving so hard on this? What is the motivation? The exact question was, is the motivation behind reinstating the third degree charge basically throwing everything at Chauvin, so hopefully something sticks? If you could talk, or Nick, why is the state pushing for this?
I have that on my stuff to talk about.
Hey.
Very good question.
You want to start, Nick?
Sure. So, a lot of times when there are several potential charges that somebody's looking at, the state usually wants a conviction for the most serious offense, for the highest one where they can get the longest prison or jail penalty. What's the most serious one? They want to get a conviction on that. They also understand that not every case is a slam dunk. Not every charge is always going to stick with a jury. So a lot of times, the more charges they can add on, the better a chance at getting a conviction. I think just like the questioner asked, hey, here, just in case we don't get second degree unintentional murder, here's one more charge for them to consider, sort of hedging our bets to say, if not this one, at least this one. Another reason for doing that is to sort of, knowing that juries like to quote unquote split the baby sometimes. Sometimes maybe there is enough evidence for any number of the charges, but the jury is sort of on edge about it, saying, well, maybe this, maybe that, we're not quite comfortable with this. So we're going to convict him of the lesser charge, just because we're not entirely sure about the more serious one. So that's a way for the state to still get in another charge with a substantial possible penalty, not as substantial potentially as the second degree murder, but just to say, hey, you know what? Okay, if they're going to split the baby, it's more severe than the manslaughter charge. So we want another serious one in there for them to potentially fall back on. is one of my takes at it. So Josh, your thoughts, or I can bounce back.
Yeah, I think that's exactly right. And I think it's sort of in recognition that there can sometimes be a gap between what we ask jurors to do and what the law sort of assumes that they will do, and the messy reality of what happens when you put 12 people in a room and tell them that they have to come up with a unanimous decision about whether to convict or not on each of these charges. And I think so sort of the reality is that sometimes that takes negotiation, it takes compromise, give and take. And so Nick gave us sort of the biblical reference of splitting the baby. I think that's something that, sort of from a legal realist perspective, you have to account for that's a possibility, that's something that could happen behind the closed doors of the jury room when they're deliberating. I do want to talk a little bit about whether or not the third degree murder is a lesser offense or not. I've seen in some of the commentary, it actually referred to as a lesser included offense, which is sort of a specific thing. A lesser included offense is a situation basically where you've got a more serious charge that basically takes the same elements of a less serious charge but adds something else on it. So if the state can prove this other thing, then it bumps up the severity of the otherwise lesser but included offense. So a good example there would be a simple misdemeanor 5th degree assault. That requires the state, if we're talking about a harm assault, the simplest type of assault, requires the state to prove that intentional act and that it caused some level of harm, any level of harm, even momentary pain, right? A slap on the face, could be a 5th degree assault. That is a lesser included offense of the felony 3rd degree assault that Chauvin, that is the predicate felony for the top count here, because that 3rd degree assault has the exact same elements, but also requires the state to prove that harm was substantial bodily harm, that it led to temporary impairment, something that they wouldn't have otherwise needed to prove for the 5th degree. So it's the same elements, but with the higher offense adding something else that's more difficult for the state to prove, but that also bumps up the culpability of the person accused.
So Josh, if you've committed a 1st degree assault, you've also committed a 5th degree assault, right?
Yes.
Got it.
Yes. Thank you. Nick can explain in 4 words what it takes me 40.
Nope, not at all.
So I don't think the 3rd degree here, though, it's not really a lesser included offense. I don't think its elements are completely different. And in fact, I'm not even sure that it's easier to prove the 3rd degree than the 2nd degree. And the reason that I say that is that I think the intent element for the 3rd degree offense is actually sort of more strict and harder for the state to establish. If you recall, the intent element for the 3rd degree, I'll see if I can go back, here we go, is that depraved mind, right? That Chauvin knew that what he was doing was imminently dangerous to Floyd, and he did it anyway, not caring what happened, right? That's a lot more specific, and I think somewhat harder to prove than the intent element in the 2nd degree, because the intent element for the 2nd degree is really just the intent element for the assault. And our courts have looked at assault as having sort of a kind of a general intent element with respect to the act. And what I mean by that is that in order to prove an assault, the state does not need to prove that the person intended to cause the harm that resulted. Instead, they just need to prove that the act that you did was something that you intended to do. And then even if you didn't anticipate or want or intend the harm to follow from that act, if that act causes the harm, it's good enough. And there's a relatively famous Court of Appeals case from from I don't know, maybe 5-6 years ago now, where a person shoved somebody who was standing near a bonfire, And everyone agreed that they didn't intend the person to fall into the bonfire, but it just so happened that this shove that was just supposed to be kind of innocent or playful caused that. And so that's sort of a good example of the Court of Appeals said, well, that's still an assault because you intended the shove and it doesn't matter that you didn't intend the harm. So in my view anyway, I think there's actually sort of an easier, simpler intent element or mens rea element for the state to prove on the second degree. So that's one of the reasons that I would say, I'm not even sure it's a lesser offense. It may even be harder to prove. And then the other thing is, even though the two charges have different maximum penalties under state statute, the second degree has a maximum penalty of 40 years, but the third degree has a maximum penalty of 25 years. That's all well and good, but if you actually look, what controls sentences for felony cases much more than the maximum penalty under statute is the presumptive sentence under Minnesota's sentencing guidelines. And Minnesota's sentencing guidelines actually categorize both of these two charges exactly the same, and they carry the exact same presumptive sentence of, I think it's about 10 to 15 years.
Josh, I am so excited that we had all of this discussion about the charges. I feel like I learned a ton, and I've gotten lots of good feedback in the chat and stuff about people having their questions answered. So thank you. Is there like 2 last minutes that you want to share about the charges before we start talking more about jury selection?
Yeah, I'll try to keep this really quick. I do think there is a potential risk for the state in charging it this way. If they end up getting what they want and having the third degree assault charge added to the case, but it comes without any clear guidance from the court about what they're going to do on the Knorr decision. And by the court here, I mean the Supreme Court. We could end up in a situation where if Chauvin were to only be convicted of the third degree, or maybe that's the only murder charge that he's convicted of, they split the baby like Nick was talking about, then I think there's a risk that if the Court of Appeals goes back to the requirement for third degree assault that existed before the Knorr decision, which means going back to saying that third degree assault does not apply where the act is directed at a single person, then theoretically Chauvin's conviction would be vulnerable to being overturned on that same logic. We may not get there. The Supreme Court, when they decide the issue on Chauvin's appeal, maybe they'll clean that up and they'll let everybody know what they expect the law to be going forward. But if that comes out murky, then I think that's a risk that we should be aware of. And I had on here stuff to talk about charging options. I mean, that was just very simply, there are other things that the state could have done. They could have charged it, either first or second degree intentional murder. That would have, committed them to trying to prove that Chauvin intended Floyd to die, which is hard for sure. But if they wanted to have sort of that menu that allowed for someone to split the baby, that's something else that they could have done.
Thanks so much for that. I think we have a couple more questions about the charges that we'll wrap back around to towards the end, because they also might come up in y'all's discussion about jury selection. But let's shift segments a little bit. I wish I had like some transition music, or we'd go to a quick commercial break, but let's start talking about jury selection. So we had a full day of it yesterday, had a little bit of it this morning. Nick, will you give us just a little bit of a rundown of like, what is jury selection? What's normally happening? And then we've got a few questions already about some of the particulars that people watched yesterday.
Yeah, absolutely. And that's perfect. If either Malika or Josh, if you could be on the slide portion, that would be great.
You.
Thanks, Josh. And also, I apologize for when my cat is sort of joining me here on the side.
That's Goose Buzz in the Tower, right?
Oh my goodness, yes. That is the best reference ever. So we'll sort of give kind of a briefer breakdown, nuts and bolts of jury selection. So as folks know, you are entitled to a determination of your guilt or lack thereof by a jury of your peers. And I'm sorry. I am so sorry, folks. This is 1 second. So you're entitled to an impartial jury. That is a Sixth Amendment right guaranteed by the Constitution. The way folks, all these random jurors are summoned is by the voter registration list and the driver's license ID list. Now, are there problems with how these random jurors are selected? Absolutely. And I think for a great video, a little more in depth on that on our website, Malika and I think Andrew made a video sort of touching on that. So I won't go into that in too much detail right now, but that's where all these like random folks come from, right? And a jury is important because they're the fact finders. So it's really important of knowing who is on this jury, who isn't on this jury. And voir dire or voir dire is a fancy way for just saying jury selection. That's how you're going to pick these folks or exclude these folks from being on your jury. So Josh, if you jump to the next one, please. Great, thanks so much. So the stated goal or purpose of jury selection is essentially to talk to these random people, right? These random folks to figure out, essentially, can they be fair and impartial to your case? Fair and impartial meaning, are they going to put aside any preconceived notions they have about the defendant, the state, the evidence, what they may have heard, right? So the base portion of it is to figure out, are these folks going to give everyone a fair shake? If a juror can't be fair or could potentially be harmful to your case, what you'll want to do is move to strike them. And when I say strike, meaning remove that juror will not be on your case. And there are really two ways that we can do that. And we've been seeing this, if you've been watching jury selection as it's going in the case, we've seen Judge Cahill sort of navigating this along with the attorneys. So Josh, if you go to the next one, please. So the two types of strikes that are out there are, number one, it's a strike for cause. The other one is what's called a peremptory strike. A strike for cause is something that you can motion for as an attorney to remove a juror, saying that they have expressed something that establishes they either can't or won't be fair and impartial. And sometimes folks don't say this directly. So if you've been watching some of the jury trial portions, they're asking, what do folks think about the Blue Lives Matter movement, for example, versus what do they think about the Black Lives Matter movement? The attorneys are probably making assumptions saying that if folks think favorably of one or the other, they're going to potentially be more biased in favor of whatever side seems to be supporting or coming from that base of the movement. A really common one, for example, if someone were to say, I don't like bald men with beards who wear blue ties, that juror is going to be removed for cause because they're not going to give me as a defendant a fair shake. And there's no limits on how many times you can make that motion. If you get the entire 50-person panel of potential jurors who comes in and says, I don't like people named Nick who are bald and have beards, and I don't believe them, you're going to make that same motion to remove them for cause every time. The other way that you can remove
All right, Nick, before you get to the peremptory strikes, there's a really specific question I think might relate to strikes for cause. So someone asked, do you have any idea why they asked a potential juror yesterday about a Northside boxing gym? Could you or Josh maybe talk about why that question might have been posed?
Yeah, really, I'll start and I'll flip it over to Josh. So my understanding from what I've been seeing is one of the folks, and his name is escaping me, who witnessed George Floyd losing his life, had a Northside boxing shirt on, and he was a member of that club, I believe, where he practices boxing and martial arts. He is actually going to be one of the witnesses testifying in the case, talking about not only what he saw, but also his martial arts training and experience, and why he was so alarmed by seeing what he was seeing Derek Chauvin doing. So I think for some reason they wanted to, there was one of the jurors practiced martial arts, I believe it was Brazilian Jiu-Jitsu. So they wanted to determine if potentially he knew that individual. So if he knew that potential witness had any ties or any connections to him. So that's my understanding or my hunch of where they were coming from with that. And Josh, if you have...
Yeah, I think that's right. And just I think the jurors are asked specifically, I think they were asked specifically in the questionnaire if they knew the names of anybody who was on the witness list. But just given the sort of martial arts connection, I think they wanted to try to figure out, well, maybe you don't know this exact person, but like, do you both have, similar ties or affinity for, this club or this organization?
For sure. So very, very good question. And like you'll see, the attorneys don't always ask, maybe they try to get to a specific answer by asking roundabout questions so as maybe not to tip a juror off as to why are we asking this, so they can give a correct answer.
Nick, can you talk a little bit about what happens when, from your perspective, when you're doing voir dire and you're like trying to develop a for cause argument, but then the other side gets to try to rehabilitate? What does that look like?
Totally. So, let's say we've established, again, to my sort of just hypothetical example, about, a potential juror not liking people named Nick who are bald with a beard, right? And they've established that, and they've said, well, I don't like this person, and coming into this, I'm not feeling good about him, right? The state would have an opportunity to try, and Josh used the term rehabilitate the witness, meaning the state would want that witness to stay on as a juror because they know that juror is going to look more favorably on their case. So they want to try to establish for the judge that, hey, judge, actually this person can be fair. So I'm going to ask them some questions, and maybe I'll ask them outright to say, Mrs. Potential Juror, you expressed your feelings about X. If the judge orders you to disregard that feeling, can you put that feeling aside, and can you truly view and listen to everything fairly and put those feelings aside? Can you do that? And sometimes a juror will say, you know what? Yes, I can do that. That's a situation where the state would then argue, hey, judge, we rehabilitated this person. They've expressly said that they're going to put aside their bias. So that motion to remove them for cause is no longer valid. All they have to do is say they can be fair. And then the judge would have to decide if that person truly was or wasn't rehabilitated. So it would make my argument a little harder at that point to establish that even though they said that, they really still won't be. Yeah, great question. So the other manner of striking or removing somebody from a jury is using what's called a peremptory strike. And basically those are just free strikes that you can use for any reason. The only caveat is that they can't be discriminatory reasons. They can't be used to get rid of folks just because they are Black, or just because they are men, or just because they are women. It can be because of an answer they gave. It can be because they have, a ton of friends who are law enforcement, or they really think poorly of the police. But what we saw, and I should say that those are, whereas strikes for cause are unlimited, peremptory strikes are limited. So typically, the defense would get 5 peremptory strikes and the state would get 3. In this case, due to the number of jurors that they're going through and due to the sort of high profile nature of the case, Judge Cahill tripled that amount. So in this case, the defense has 15 peremptory strikes. They started with 15, and the state gets 9. So the numbers were much higher for this type of case. What we saw is really interesting. It's what's called a Batson issue. So Josh, if you go to the next slide.
Trying.
Thank you. Oh, that's okay. Thank you, sir. So a Batson challenge, Batson is the name of a Supreme Court case that really outlines and creates this rule of attorneys, you can't strike people for a discriminatory reason. And if the other side thinks you're doing that, they can challenge that. And we saw that this week, and it's sort of actually called a reverse Batson challenge because it was the state challenging the defense use of a strike. So the state felt that the 2 strikes that had been used by the defense were done to folks who, again, we can't see them, so relying on what they're saying, 2 folks who were Hispanic. So the state said, hold on a second, we think you're just getting rid of people because they're Hispanic. And that's step 1 of that Batson challenge process. So the state raised the issue saying, Judge, there have been 2 strikes now, and they have both been Hispanic people. once that has been shown, that prima facie, that initial threshold, the other party then has to come up with what's called a neutral reason to justify that strike. And they can't use race. So they would have to give a different reason other than that. And the reason that the state offered in this case, the defense offered in this case to the second strike, was that the individual expressed an opinion that he practiced Brazilian Jiu-Jitsu, and he believed that the technique that Derek Chauvin used was wrong and dangerous, essentially. And the defense probed him on that, and essentially the juror said, well, that's my opinion, but if you prove me wrong, if you present evidence proving that my view is wrong, yeah, then I'll listen to that evidence. It then goes to the judge to make the decision. So that was the reason the defense primarily gave. And the judge denied the Batson motion. The judge said, hey, the defense gave a valid reason. They didn't strike him because he was Hispanic. They struck him, they used this peremptory strike because he essentially shifted the burden to the defense. He said that he's going to hold on to an opinion and make the defense prove him wrong. And I think as much of all of our opinions, are fairly out in the open about this, in every criminal trial, the burden is always on the state. The burden is not on the defense. So that was the basis that Judge Cahill gave. So this reverse Batson challenge was unsuccessful. But that's sort of that three-step process. So the party who's objecting needs to object and point it out. The party who did the striking needs to give a neutral reason. And then the judge needs to decide if that neutral reason was truly neutral or truly good enough. In this case, Judge Cahill decided that the reason was legitimate, and he denied the motion.
Nick, we had a question come in from Facebook, and I wonder if it might be answered in this Batson challenge, but maybe it's taking us also a step back to some of that striking for cause. So the question is, this person noticed early on that the defense attorney declined to ask questions of a potential juror who, in their opinion, had shown some bias. So is it likely that the defense attorney knew that the judge was going to dismiss that juror, or maybe the judge was waiting for a Batson challenge? Do you have any sense of maybe why the defense attorney wouldn't probe any deeper in a particular person who was showing bias?
Yeah, good question. And I don't actually specifically remember that one. So if Josh did, I can turn it over to him. But off the cuff,
I wonder if it's the person that was the first peremptory strike, that it almost seemed like that the defense attorney had sort of made up his mind that he was going to use that strike. If anything.
Yeah, let's talk about that. So that was the juror who the defense did end up striking, and the defense actually made a motion for cause, I believe, arguing that the juror's language ability was insufficient to fully participate in the trial. I think their primary language, I believe, was Spanish, with English being their second language. So they did actually make a motion to remove that person for cause, saying, not that this person is biased, not that this person, has necessarily strong opinions one way or the other, but Judge, we're concerned that she won't be able to fully participate or understand the proceedings. Judge Cahill rejected that. Judge Cahill said, I do understand that language is that English is her second language, but she seems, in Judge Cahill's opinion, to have understood everything well enough where he felt she could have participated. The defense in that case then still had concerns about it, and they ended up using one of their peremptory strikes in that case. In terms of not asking a juror questions, though, it could be the defense doesn't want to ask that one question too many, where maybe the bias is good in their favor and they don't want it to come out anymore to help the state remove them for cause. Or it could be that maybe they do have a gut leaning that the judge sort of might be ready and ripe to hear a motion already.
And then in that case, you might not want to ask one too many questions that does the state's job of rehabilitating them for them.
Exactly. Yep.
You want me to move forward?
Yeah, please. Yep. And great question. So these are sort of the less meatier aspects, but still important. So, we're going through a large number of jurors here. In a felony case, the folks who are actually going to go back and make a decision as to whether someone is guilty or not guilty is going to be 12 jurors. In a gross misdemeanor or misdemeanor case, it's 6 jurors. So cut that number in half. That can be fudged if the defendant and the state agree to it. That would be a really odd scenario. I've never seen that come up, and I don't imagine where it really would come up. And then they usually, under normal circumstances for cases, they have one alternate. So 12 will actually go back and make the decision, but during the trial, there will be 13 people listening to all the evidence, taking everything in. The reason for that is in case one of the actual 12 gets sick, doesn't show up, for some reason isn't there, then they have that additional person who's still heard the evidence and can slide in, take their place, and go back and make a decision with them. The attorneys and the judge know who that alternate juror is. We do our best to make sure that the alternate juror doesn't know who they are. And the reason we do that is because we want everybody paying attention. If somebody knows that they're the alternate, they might sort of slack off and think, well, I'm not going to be a part of this anyway, so why bother? That's not something that we want. In this case, because just the magnitude of the case, the unique circumstances of COVID, there are going to be, I believe, 4 alternates. So there will be 16 jurors listening to the evidence. At the end of it, still only 12 of them will go back to deliberate. Thanks, Josh. And again, like we talked about at the beginning, so the jury is important for the huge reason that they are the ones who decide whether a defendant is guilty or not guilty. That's sort of where everything is like out of the judge's hands, it's out of the attorney's hands. It's where the random folks, the jury, are the one with the power at that point. Their verdict has to be unanimous, whether it's for a guilty verdict or a not guilty verdict. Again, that can be reduced if the state and the defense agree to it, which again would be an odd scenario that I wouldn't anticipate seeing. And I think that's it for the jury stuff, unless there are other specific questions we can talk about.
There's, I think, one more question that would help close us out here and tie into our next session. So a person asks that they've heard Keith Ellison say that it's hard to convict a police officer, and they assume that he means it's harder than a person who's not a police officer. Can you talk just a little bit more about like that decision that the jury is going to have to be making around guilty or not guilty, and what that might mean in a case with a police officer?
Yeah, let me start by saying that I think probably one of the big sections that we'll do at a future meeting will look at what some of the defenses might be, what the arguments that both sides might be arguing. And I think that will be a place where we can get in more depth on this. But I think, what Keith Ellison is talking about kind of goes to a number of things. First, it goes to the actual defenses that are available. So with a police officer, with anyone charged with a sort of a violent crime or a crime that causes injury, one of the defenses that's available is self-defense. And it's an affirmative defense. So it actually sort of exists outside of the elements that we were looking at before. The way that an affirmative defense works is even if the state has proved those elements, the defense can argue that it was justified to take that action for some other reason, for self-defense. Or with the case of police officers, there's basically the law allows for sort of law enforcement's authorized use of force. And there's U.S. Supreme Court case law, Graham v. Connor, I think.
Yep, exactly.
That sort of sets out the kind of the baseline rule and sort of gives us why it's sort of easier for a cop or a police officer to sort of make that law enforcement use of force or sort of law enforcement self-defense claim versus a non-cop making a traditional self-defense claim. And what Graham v. Connor basically said was that the officer is able to use a reasonable amount of force to defend themselves and others when it's reasonable for them to feel that they need to be afraid of the person that they're interacting with. Some of us call this the reasonably scared cop rule. But what Graham v. Connor does that sort of distinguishes that from the typical self-defense claim is it says that this sort of reasonable analysis that we go through in deciding whether the cop's actions were justified isn't the objective reasonableness from the perspective of any average person. It's instead a reasonableness from the point of view of a trained police officer. And the practical effect of this is it allows for the introduction of expert witnesses, and we'll see these expert witnesses in the trial here that will be like law enforcement trainers that will talk about basically all of the difficulties that cops have to be thinking about and the split-second decisions that they have to be made and how they're trained to be afraid all the time. And that has the effect of basically, in my view and in a lot of people's view, allowing an officer to go to deadly force on a level of fear that is a lot smaller than an average person would get away with. And that's something that we may see coming up because a layperson looks at the Chauvin situation and just cannot comprehend how they could have felt like it was justified to use force for minutes on end, kneeling on his neck while he's in custody, while he's handcuffed. And the defense is going to be able to present law enforcement witnesses who are going to be able to present sort of a litany of reasons that a cop might think, that might be reasonable from the perspective of a cop, even if it shocks the conscience of all of the rest of us. And that's just simply not a defense that non-cops have. So that's one of the things that Ellison is getting at. I think the other big thing is just cops are agents of the state. We saw a bunch of the jurors here so far say that they have good opinions of Blue Lives Matter, good opinions of cops. They trust cops. They feel like their communities are safe. And so I think one of the things that is typically a burden or barrier for a defendant is that they come in with a credibility disadvantage vis-a-vis the state. And what I mean by that is that jurors tend to view the state favorably, and there's a lot that comes with just being accused of a crime by the state. And just by being put in that position, even though they're going to be instructed on the presumption of innocence, you've got this sort of, well, you're the person accused, you're probably going to say anything that you need to say to defend yourself. The state is more neutral here. They don't have as personal a stake in it. They're part of the system, that the system has worked for me. And all of that sort of comes into play too. And so I think those sort of two factors gets to what Keith Ellison was talking about.
Awesome. Thank you so much for explaining that. And thanks so much to Josh and Nick for answering all these good questions and providing some good legal foundation for folks who are watching the trial. Thanks to everyone who stayed and tuned in and submitted questions and comments are super helpful. We'll be doing more of these, including a community panel on Monday. We'll be talking more about this third-degree charge and what that could mean moving forward. Next week, we'll have some opportunities on social media for folks to submit questions to us via Twitter and Facebook and Instagram Live. And then we'll be back here in 2 weeks as we're entering the last week of jury selection and looking towards the opening statements in the trial to talk more about this burden of proof and evidence in the cases to be made. So thanks so much for being with us today. Have a good afternoon, everybody.
Thanks, everybody.